Ready.
So, good evening, everybody, and welcome to this STARS Legal Studies webinar. My name is Matteo Monti, and I am a postdoctoral researcher at the Sant'Anna School of Advanced Studies, and I have the pleasure of chairing this book presentation. On behalf of the STARS directors, Giacomo Delle Donne, Giuseppe Martinico, and Filippo Fontanelli, I'm delighted to welcome you all to today's webinar featuring the presentation of the book Asymmetries, Courts and Comparative Constitutional Law by Lidia Bonifati. The book was published by Brill in the Studies in Territorial and Cultural Diversity Governance series. And so maybe, Giuseppe, could you please show the book, because I don't actually have a copy.
Yeah. Can you see the book? Right.
Yeah.
What
Thank you very
wonderful
much, Giuseppe.
cover, terrific content.
Nice.
Here we
I agree. I completely agree. So we are very pleased to see such a strong interest in this book and in today's discussion. As for the format of our webinar, first we will have Lidia, the author of the book, who will introduce the book and share the key elements and the motivation behind the book. And then we will hear from our two discussants who will reflect on and engage with the book. We have the great pleasure of having as discussants Maja Sahadzic, University of Utrecht, and Nicolò Paolo Alessi, UniDistance Suisse, and the University of Neuchâtel. After these interventions, we will open the floor for a Q&A session with the audience. Our goal is to conclude the webinar at 7:30. So before we begin, a few brief housekeeping notes. We are going to record the webinar, so if you don't wish to appear, please switch off your camera, and please keep your microphone muted. You may write down questions in the chat during the webinar, and we will collect all the questions in the Q&A session. Otherwise, in the Q&A session, you can raise your virtual hand, and I will give you the floor. So, without wasting our precious time, I will now give the floor to Lidia. Lidia Bonifati is a postdoctoral researcher at the University of Bologna. And what else? Thank you very much, Lidia, for being with us today and for accepting our invitation. The floor is yours. You have 25 minutes.
Yes. Thank you so much, Matteo. Good evening, everybody, and thank you so much for joining us tonight in this webinar. Before I begin, I wanted to thank Giuseppe Martinico and Giacomo Delle Donne for organizing this webinar, and I'm really happy that my first book presentation is with the STARS friends. It's really reassuring. And I want to also to thank Matteo, Maja, and Nicolò for agreeing to participate in this presentation. They are all amazing researchers, and they have inspired me during my work on the book. So I'm really, really happy and really grateful that they are here with me tonight. In this 25 minutes, a little less, I wanted to outline the core ideas and goals that are behind this book. First of all, a little disclaimer: this book is basically an evolution of my PhD thesis. After I defended the PhD in 2023, I decided that I wanted to keep working on the topic of constitutional asymmetries in divided multi-tier systems, and I wanted to go a bit beyond what I've studied and done during the PhD, from both a theoretical and methodological standpoint. And so we'll divide this brief presentation into two parts. The first part reflects basically the first part of the book, meaning a first goal was to explore the topic of constitutional asymmetries in divided multi-tier systems from a theoretical perspective, and I wanted to address two main gaps in the literature. A first gap was a more nuanced conceptualization of constitutional asymmetries. And I wanted to frame them not only as an instrument to address diversity, to manage internal conflicts, but as a constitutional model to address diversity, to accommodate internal diversity. And to study constitutional asymmetries, I decided to conduct a comparative analysis that was functional to highlight, to make some dynamic feature emerge. And so I conducted a comparative study, a comparative analysis on 12 constitutional systems, both from the global north and the global south. And I employed the theoretical framework on asymmetries derived from the framework on subnational autonomy and cohesion developed by Patricia Popolier in her book on dynamic federalism, and on the previous works on constitutional asymmetries. Maja Sahadzic is here with us, so she knows very well that her work has been absolutely essential as a foundation. And on the previous works, I built a sort of dynamic representation of asymmetries in divided multi-tier systems, because from the comparative analysis, three main aspects emerged. Some of which I anticipated, some others that I did not anticipate. The first element was basically an empirical test of what has been argued by the literature, namely that asymmetries can be introduced according to different degrees of intensity. So I framed these degrees along three core degrees, so low, medium, and high. And I expected that asymmetries would have varied across case studies. An aspect that I found particularly interesting and enriching was that I noticed that asymmetry was different also within cases. So it varied across dimension of asymmetry. So I used a classic framing of asymmetries along the dimension of powers, of stages of powers and competencies and fiscal arrangements. And I noticed that some countries displayed asymmetries in all three dimensions, some others only in one dimension, and in the other two they were symmetrical. And I noticed that even those cases that were asymmetrical in all three dimensions, this asymmetry was not necessarily of the same intensity. It could be low in one dimension of powers and high in fiscal arrangements or in status. So the first result was a highly complex picture of asymmetries, not only across cases, but also within cases. A second aspect that emerged from the comparative analysis was that asymmetries were introduced in a great variety of settings in terms of models of territorial decentralization. So it's not only a model adopted by federal states, by federations, but also by regional states. We have it in Italy and in Spain, but also in formally unitary systems that adopted forms of territorial decentralization, such as Indonesia, and or with devolution of powers, such as the United Kingdom. That was a highly contested case, and we will perhaps discuss it in the Q&A or in the discussion with Maja and Nicolò. So, so this second element, in a way, demonstrated that it is a highly flexible and more acceptable model to accommodate diversity, and can be introduced in a flexible way in different settings. And then finally, the comparative analysis of this constitutional design perspective showed that constitutional asymmetries do not belong to a specific constitutional tradition. So they can be found in the global north as well in the global south, from Canada to Iraq, to India and Indonesia and Bosnia and Herzegovina. So it's widely adopted. And this was really interesting for me as I wanted to systematically explore the adoption of constitutional asymmetries. So overall, asymmetries proved to be a dynamic constitutional model from a constitutional design perspective. They have been introduced in many settings according to different degrees, depending on the specific context and needs of the constitutional systems. In the second part of the book, I wanted to address a second gap, that is the role of constitutional courts. The role of courts was something that I was not able to address during the PhD, and was actually one of the most interesting comments that I got during the defense, and that I treasured during the creative and chaotic process of transforming the PhD thesis into a book. I wanted to really dedicate almost half of the part of the book to the role of courts. And in this sense, some previous works had the intuition of advancing the idea that courts are a really important player in shaping asymmetries, but it haven't been systematically explored as actors in asymmetrical constitutional systems. So what I've done was to use the same conceptual framework of asymmetries divided along 3 dimensions, of status, powers, and fiscal arrangements, and see how constitutional courts or supreme courts, so at the apex of the judicial systems and entitled to judicial or constitutional review, interpreted asymmetries in their case law. A first information to have is that very little courts address asymmetries in their case law. So of the 12 constitutional systems I analyzed, actually only 5 courts addressed asymmetries. So the Indian Supreme Court, the Italian Constitutional Court, the Spanish Constitutional Tribunal, and the 2 apex courts in Indonesia. Indonesia overall has a very limited case law on federalism related disputes, but the very few they have, they can and they do address asymmetries. So the Indonesian Constitutional Court and the Indonesian Supreme Court. And the case law was very fascinating in the sense that, of course, there are not many courts, so we cannot make any generalizable assumption on how courts behave. But these 5 courts overall tend to reduce the space of asymmetry. So in a sense, contradicting what I've addressed in the first part of the book, saying that constitutional asymmetries can be much more acceptable as a constitutional model. And overall, these courts interpret asymmetries as something threatening to the integrity of the constitutional system. And so if they have to choose between asymmetry and symmetry, they tend to choose a symmetrization trend, okay? So they tend to prefer a completely equal treatment across subnational entities, and they tend to support symmetrizing legislation, okay? But even in this sense, the case law analysis confirmed a huge degree of variation, okay? The court's behavior changed a lot depending on a few factors. First of all, depending on the specific context. The Italian Constitutional Court in this sense is really emblematic because it supported asymmetry for a lot of time, and then with the 2001 constitutional reform and the crisis of the early 2000s, so with the economic crisis and the pandemic, when the overall system was in crisis, the Constitutional Court chose centralization, symmetrization, and upheld the central government decisions in terms of asymmetry. And so reduced the space of asymmetry, but it didn't do it systematically across its case law. A second aspect was the behavior changed depending on the subnational entity involved in the dispute. And in this case, the Indian Supreme Court was really, really fascinating in the sense because the case law of the Indian Supreme Court showed me that the case law concerning the northeastern states that have specific arrangements on maintaining some traditional rights and have specific arrangements that derive from the accession to the Indian Union is very, very different and much more coherent than the case law concerning Jammu and Kashmir, so the former state of Jammu and Kashmir. And the Indian Supreme Court and its decision on the abrogation of Article 370 of the Indian Constitution on the special status of the state of Jammu and Kashmir is really, really effective in showing how much and to what extent a court can redesign the degree of asymmetry within a constitutional system. Because by confirming the abrogation of this article of the Constitution, the degree of asymmetry of Jammu and Kashmir came to almost zero, because it was demoted, in a sense, to a union territory with much more limited space for symmetry, and the overall degree of asymmetry in the Indian Union decreased a lot. And in the sense, conducting a comparative analysis, a synchronic comparative analysis was in a sense limiting, because I could capture asymmetry in 2022-23 and not the previous degrees of asymmetry. It also, the behavior of courts also depended on the dimension of asymmetry involved. So again, looking at the case law of the Italian Constitutional Court, the cases concerning asymmetry in status saw a court much more careful in preferring a setting, a symmetrical setting, because the principle of specialty in the Italian constitutional framework is a core principle of regionalism and of the form of state. So it was much more careful in saying that the symmetry is preferable. But in the dimension of powers and fiscal arrangements, if the system was in distress, it chose symmetry. So we can see that there's a lot to consider when understanding and studying the behavior of courts and the outcome of this case law on constitutional asymmetries. Overall, the impact of these decisions on constitutional asymmetries has a great impact. It's really, really profound on the constitutional system. We can see it in Spain with the decisions on the special status of Catalonia. We can see it in India with the decision to confirm the abrogation of Article 370. And so overall, I think that the second part confirms that studying constitutional asymmetries not only in terms of constitutional design, but also in terms of jurisprudence and the case law of apex courts is really an essential element. And let's say a final goal of this book, coming to an end, was to challenge comparative constitutional law from a methodological standpoint. So the interest was not only theoretical, but also methodological. And in particular, I wanted to offer a qualitative and a quantitative assessment of constitutional symmetries. And to do so, I relied on Patricia Popolier's indexes on subnational autonomy and only on subnational autonomy in my case. So I did not employ the indexes on cohesion, but this allowed me to test these indexes and to apply them to a variety of cases and to systematically analyze constitutional symmetries in all three dimensions. And of course, this proved to be really, of course, in a way time-consuming, but I think it was really worth it because I found it really, really engaging. And it showed that comparative constitutional law can engage in empirical legal studies as well, not only with, hardcore statistics, but also with indexes that employ categories and can support a more traditional doctrinal and legal analysis. And finally, another perspective in methodological terms that was really important for me in this book was to adopt a decolonial approach, in the sense that I wanted to engage with the legacies of colonialism, not only including some countries from the global south, also because the majority of cases are from the global south, and but also reflecting on the role of colonialism in rejecting or accepting constitutional asymmetries in their frameworks, because in some cases these were impositions and they were accepted as such. In other cases, they were rejected almost to the maximum, and so the degree of asymmetries were very, very minimal and only functional in keeping the system together. But this is something that I found it really, again, really important in having a more complete picture of constitutional asymmetries in divided multi-tier systems, because it would have been an incomplete image of what asymmetries are in contemporary constitutional systems. And taking together these two elements, I think that it offered a more complete picture of constitutional asymmetries, and it offered an analytical strategy to be replicated by other researchers. This was really, really important for me, namely showing that my work can be also disproven in a way, because other researchers can take different, can make different choices. And there is a degree of subjectivity in doing this kind of comparative analysis that it's inevitable. And I hope that this work can spark some discussion and can be enriched by others that can make different methodological choices and add to this first work. So I think I can stop here. I don't know, Matteo, if I'm within the time.
Perfectly. I mean,
Yes.
you have 4 minutes if you want to use them. Otherwise, I will.
I think that
Up to you.
we can
Okay.
leave the floor to the discussants. Thank you so much.
Okay. So thank you very much, Lydia, for this insightful and stimulating presentation. I have taken plenty of notes, and I believe that we can now turn to our discussants. And according to the flyer, our first discussant is Nicolò Paolo Alessi, who is postdoctoral researcher at the UniDistance Suisse and the University of Neuchâtel. Let me briefly say that Nicolò has recently published a terrific book, A Global Law of Diversity, Evolving Models and Concepts. And I believe this work engages closely with some questions and issues raised in Lydia's book. So I'm looking forward to hearing what Nicolò is gonna say, and we are really happy to have Nicolò Alessi with us today. So Nicolò, please, the floor is yours.
Thanks. Thank you very much. And thank you first, Giuseppe and Giacomo, for inviting me to discuss this wonderful book. And congratulations again, Lydia, on this publication that makes a great contribution to the comparative studies of asymmetries. And thanks, Matteo, for your endorsement. You also already discussed my book, and I also wish I will have my opportunity to discuss my book in this very STALS meeting in the future. In my comment, I will try and retrace the path of the book, and I will try to underscore its many contributions to comparative constitutional studies, and I will also ask some questions. Lydia, in her book, she aims to prove two main hypotheses, right? She aims to prove that constitutional asymmetries in divided multi-tiered systems come in different degrees, so they are a flexible constitutional model for the accommodation of ethnocultural diversity. And then the second hypothesis is that constitutional courts tend to interpret asymmetries as threats to the integrity of the system and generally tend to reduce the degrees of asymmetry through their decisions. And the book is structured accordingly, so following these two hypotheses. So there's a first part that basically focuses on constitutional asymmetries from an institutional standpoint through literature review, a description of what asymmetries are and how to measure asymmetries from an institutional standpoint. And then we have this second part focused on the activity and role of courts. I would say that a very first important contribution of this book is this terrific and huge literature review on constitutional design for divided society that we can find in chapter 1, which bridges literature from political science and comparative constitutional law. And also, in addition to that, she also shows the links that these two strands of literature have with federal studies. And then we can say we can see a very huge work on literature and a very first attempt to bridge this literature coming from these two different disciplines, and that was very useful. That will be something that I will use often in the future to just also refresh. And then the result of this literature review is her first argument, actually. She argues that asymmetries in divided multi-tiered systems can be seen as the most suitable or the most widely acceptable model to manage ethnocultural diversity. And then maybe here I can already ask a first question. That is, I was wondering in which sense a model is different from an instrument for the accommodation of diversity, because you try to make a point really on the fact that asymmetries are a constitutional model and the most acceptable constitutional design solution, also because it's a middle ground between other models that have been presented. So I was wondering if you consider it as a model like a fully fledged model that doesn't need to be complemented by other instruments for the accommodation of diversity. That comes from me actually, yeah, because I wrote this book on the accommodation of diversity. So I was wondering this. And then if we move on to the other chapters of the first part, Lidia goes on to defining and measuring asymmetries. So she describes de jure and de facto asymmetries, but then she describes and opposes this framework for empirical measurement of constitutional asymmetries based on institutional factors, so status and fiscal arrangements. And that is, I would say, the main contribution, as far as I'm concerned, of this book. This methodological contribution and this measurement contribution. So Lidia uses social science methods, empirical methods to enhance the understanding of legal phenomena and explore constitutional asymmetries. And this is in line and building on Patricia Popelier and Maja work on asymmetries. And that's something that I find very, very interesting, because it also lays the foundations for further work, and also to go even a step further, working on what Hirschel define as causal claims. So it's she addresses also really a gap in literature which had not before this book yet found ways to systematically explore different degrees of constitutional asymmetries. So with these measurements, she is able really to provide a more nuanced picture of constitutional asymmetries using empirical methods, but also proving and testing them always with qualitative methods and qualitative analysis and literature review. So she's also very good, I would say, at describing her method. She describes very well her steps to measure asymmetries. So she measures asymmetries choosing two subnational entities per case studies. Then she measures the degree of asymmetry within the system, and then she finds a way to measure to compare the degree of asymmetry across systems, and that also required a lot of work, understanding normalization and other stuff, more specific methodological stuff. So yeah, this part of on the measurement, it's something that should be really focused on when reading on this book. But it really provides a picture of constitutional asymmetries, which is further described and described in detail in chapter 3, if I'm not wrong. So she describes how asymmetries unfold in these 12 cases. So we have high degrees of asymmetries, medium degrees, low degrees. And then she always also shows it makes like a reality check of asymmetries through an analysis of asymmetries in action. So how asymmetries have been then implemented, or they have been evolving in these systems. So from this first part, another great contribution is that constitutional asymmetries can vary not only among cases, but also among dimensions, as already Lidia said. I would say also the importance of using empirical methods, but also the importance of using them carefully, because we don't want to dare too much using them. And then the important point on this reality check on asymmetries implementation and this tendency towards resymmetrization. This work on measurement of constitutional asymmetries from an institutional point of view that also complements Maja's work, but we will leave Maja talk about this, is complemented itself by this analysis on courts. and the accommodation of diversity. I found chapter 4 of the second part very interesting and a very brilliant illustration of the role of courts and other quasi-judicial bodies in the accommodation of diversity. She makes really a point. We have to focus on courts. I have to say that to myself as well, because that was something that also was mentioned in my work. And so she described the role of many courts to make this point, and then she focuses in chapter 5 on courts and asymmetries in the 12 cases that she studied. So as she said, she studied before the judicial decisions of apex courts on federalism-related cases, and then on asymmetries specifically. And I would say this is another great contribution of this book, is that we can find some insights and some very, I would say, clear, but also to be debated, still to be debated insights on the role of courts. So the two main insights are that courts tend to adopt a centralist behavior and favor centralist trends in federalism-related matters. And then courts tend to reduce asymmetries, and then these trends, I see a correlation with these trends, with the trends that Lidia analyzed before, that also show this tendency of resymmetrization in these systems. So here's the question that immediately came to mind. Based on your initial statement on the desirability of asymmetries in multi-tiered divided systems, how do you explain this trend that seems to move to the opposite direction, actually? So we create asymmetries because we think that asymmetries can be good for ethnocultural diversity management, but then asymmetry are reduced. This also in a way relates a little bit with Maja's research and work on the risks of asymmetries for stability and legitimacy. So I would just like to know a bit more about that. And the last question is related to the how broad can be the measurement, and that's something that really interests me a lot. So you mentioned many other factors and elements that conditioned asymmetries, and there are also extra legal factors analyzed by Maja, for instance. Do you think that these further elements and also the activity of the courts that affect the evolution of asymmetries can also be included in a measurement? So do you think that we can include them as further factors to be attributed scores to measure asymmetries? Because in my view, if it was possible, this would really further enhance the value of this already wonderful research. Thank you very much.
Thank you very much, Nicolò, for those very super interesting comments. So our second discussant is Maja Sahadzic. Maja is assistant professor at Utrecht University. Her work needs no introduction, as she's one of the most important experts in the field of asymmetric federalism and also minorities protection and etc. Maja Asymmetry, Multinationalism and Constitutional Law book is a seminal work on constitutional asymmetry. So we are very grateful to have you here with us, Maja. And what else? The floor is yours. Thank you.
Thank you so much for inviting me. And I have to say that this, at the very beginning, this book is important. It is an ambitious contribution to the studies of the constitutional asymmetries. I'll tell you why, but first I have to make some kind of intellectual positioning to this. First of all, this book takes on three very large conversations at once. There's federalism theory, there's constitutional design in divided society, and then there is the role of courts in multi-tiered systems. And as we all know, taking on one of these would already be enough to lose sleep over, right? But taking all three suggests either courage or a PhD training in Antwerp. And Lidia and I, we know what we are talking about because we both had PhD training in Antwerp. So it's probably both, I would assume. Before I start, I think I have to briefly acknowledge something that may seem a little bit self-referential, because the field of constitutional asymmetry, especially when it's connected to multinationalism, federal design, and so on, is still relatively new, underexplored. And there are not many monographs that tackle these conversations head on. As a result, those of us that are working in this area, inevitably we found ourselves in conversations with each other's work. And so I will mention my own book, not out of some kind of self-citation reflex, but because it really forms a part of that limited body of scholarship that frames the debate Lidia is entering, but not only entering, reshaping. So when I wrote Asymmetry, Multinationalism, and Constitutional Law, my central concern was to understand whether constitutional asymmetry is linked to multinationalism, and then whether asymmetry strengthens or undermines legitimacy and stability in federal or federal-like systems. Lidia's book does overlap, as Nicolò said, with that project. However, it significantly expands it. It is complementary, but I have to say it is also very innovative. It takes asymmetry out of what I thought when I was reading, what I would call structural comfort zone. It places it into a new constitutional ecosystem that is shaped by courts, and that is a new angle that we genuinely do not know enough or much about. And this is precisely why situating her book against earlier work, including my own, is not merely appropriate, but it's necessary, because in the field this specialized, mapping the intellectual terrain is part of what I think of doing justice to the contribution. So what I would like to do today is actually threefold. I want to identify three major points that overlap between our works. And then I want to tell you how the book actually moves the field forward, which I think is the most important part. And then I might offer a few reflections and questions to push the debate a little bit further, in a friendly Antwerp tradition of never letting each other rest intellectually, I think. So let me start with some of the major points of overlap. I think that both books reject the traditional assumption that symmetry is the natural or even superior state of federalism. We all know traditional federal theory has long assumed that, equal constitutional units, parity, symmetry as an integrative virtue, and so on. But I think both of our works argue that this assumption no longer holds empirically, normatively, and so on. Asymmetry is not an anomaly, it is not an accident, it is structurally embedded in many contemporary systems. However, where my work examined asymmetry as a response to multinationalism, Lidia situates this within divided multi-tiered systems, and thereby she broadens the conceptual field. This is an important shift that she offers in her book, because asymmetry becomes not only a multinational accommodation tool, it becomes a broader mechanism of diversity governance. And I think this partially answers your question, Nicole. Then the book adopts a dynamic understanding of federalism. We did have the same mentor. In my work, I treated multi-tiered, multinational systems as evolving structures, in which constitutional asymmetry is linked to legitimacy and stability concerns and so on. But Lidia, she pushes this dynamic understanding further. She explicitly distances herself from rigid definitional debate. And what she does instead is that she focuses on federalism as interaction, as practice, process, and so on. And this is really, really refreshing, because we have at least two of us, and you probably, Nicolò, we have attended conferences where people debate for 45 minutes whether something is a true federation and then forget to analyze what it actually does, right? And this move away from this static federal theory towards, dynamic federalism represents a broader shift in the field. And in that shift, the books are not competing; they're complementary. I think in the stages of development. I have to turn on the light. And then what I also think is very, very important about the book, and you mentioned it to some extent, Nicolò. The point of overlap lies in methodology. I do propose indicators, index of constitutional asymmetry, and the goal for me was simple: move asymmetry from, I don't know, some kind of metaphor to measurable constitutional structure. Because once you start measuring something, it becomes much harder for federal theory to ignore it, you know? And then Lidia engages with this explicitly. She incorporates measurements into her framework. She builds on the dimensions of status, powers, fiscal arrangements, and then she integrates quantitative and qualitative analysis. But what she does good is that she does not replicate. She does not just replicate, I think. She operationalizes, she refines, and the measurement is now embedded in a broader institutional and comparative framework. So I'm happy to see that asymmetry is no longer just a concept. It now has a structure, it has scores, it has dimensions, and it has become, in a way, not just empirical, dangerously empirical. And that means unavoidable, right? Now let me turn to where the book makes its most significant advance, or advances. Bringing courts to the center. This is the real innovation. Lidia does something different, and I think that is crucial. She asks the question, what role do constitutional courts play in shaping, stabilizing, destabilizing asymmetry? And I think this shift is actually transformative for our studies, because asymmetry now is no longer treated as, a fixed structural arrangement in a constitutional text. Now it becomes something that is very practical, interpreted, recalibrated, expanded, restricted, and so on. So, as we know, once courts enter the scene, nothing remains purely structural. And from the comparative examinations of courts, she also shows that courts can act, as she acknowledges, as centralizing umpires, federal facilitators, polarizing actors, and so on, which is kind of a polite academic way of saying sometimes we help, sometimes we complicate, sometimes we make everything worse, but that's what it is. In reality, this adds an institutional layer that my earlier structural analysis did not fully develop. It moves asymmetry from very, very static design into a very living, practical constitutional environment. And that is, I think, the book's strongest and the most original move. I want to reiterate something that you mentioned, Nicolò, but not necessarily in a way that I might phrase it. I think that another major expansion of the book is theoretical, because the book bridges two literatures that have often developed separately. And when I say that it's power sharing literature and federalism literature, somehow it feels counterintuitive, but it's not, especially when we talk about asymmetries. Why? Because power sharing scholarship has long debated the destabilizing potential of asymmetry, but it has rarely measured it systematically. And on the other side, federal theory often avoided multinational divided contexts. And so when Lidia engages with power sharing and federalism, her contribution lies in bringing these conversations together. And you're right, bringing together political scientists and constitutional lawyer type of opinions and discussions to talk to each other, that is not a small achievement. it may even be harder than managing asymmetry, I can tell you that. So this makes the book relevant beyond classic federations and even beyond multinationalism. And I like that you mentioned, Lidia, that you deliberately integrated cases from the global south and that you moved from this Eurocentric North Atlantic bias. Because this is not just, because you say that this is not just empirical expansion, it is also conceptual expansion as well. Because you challenge those implicit hierarchies in federal theories that we are used to. And you push towards more inclusive methodology. And in reality, you also decolonize the knowledge. Now I have a couple of questions that I often get asked in conferences, and I never have the answer to, because these are million-dollar questions. One of those questions is asymmetry a permanent structural feature of any multinational divided system, whatever you call it, or is it a transitional mechanism? So what do we do with it? When is too much of asymmetry too much? Something what Nicolò already asked. And then the second one, closely related to your work on courts. Both of our works differentiate between, for example, status, powers, and fiscal asymmetries. But do courts really treat those differently? Are fiscal asymmetry, for example, more politically, how can I say that, explosive than status asymmetries? Is there any difference there? I'll leave the third one for later, if there is no question, which I'm sure there will be, but just in case. And let me conclude that this book moves the debate from constitutional architecture to constitutional behavior. So from what asymmetry is to what asymmetry does. And of course, compared to my work, that is a much more unpredictable story. What Lidia shows us is that once you measure it, courts will reinterpret it, politicians will politicize it, and scholars will argue about it, right? So asymmetry is not just a constitutional feature, I think. For you, it might be a career strategy, Lidia. And so on that note, congratulations, because you have successfully ensured that none of us in this virtual room, but in general, will ever be able to treat asymmetry as a simple concept again. So congratulations again, and thank you for the opportunity to comment on your work.
Thank you very much, Maja, and I fully agree with with the last statement by you. And thank you very much for those rich and engaging, all the rich and engaging reflections. So, if Lidia agrees, I will now like to invite her to react, to respond to the comments, questions, remarks raised by our discussants. Or I don't know, Lidia, do you prefer to collect more questions or?
No.
Okay.
If you agree,
Yeah,
I would
sure.
start from these, and then we can.
Yeah, then we will open the floor
for all the
to
questions.
the audience. Yeah,
Great.
for sure. Please, the floor is yours.
So, first of all, thank you so much for your comments. It's really an honor for me to have both of you commenting on my work. And you really know how much you contributed to this book. And I think that you pose partly overlapping questions. So I think I will, in a way, treat them as a whole, because much of what you're asking relates to the challenges that that are perceived to be arising from constitutional symmetries, and first and foremost the threat of inequality. And in this sense, I think that this is a sort of sin that the narrative on asymmetries in traditional federal theory has. And so starting from the last questions by Maja, so how much asymmetry is too much? And that is something that is difficult to quantify, but in terms of concept and from a theoretical perspective, of course, it is too much when it is not sustainable for the system anymore. And we have the great privilege of having Matteo and Giuseppe here in this webinar that have long studied the concept of sustainability of asymmetries. And I fully agree on the fact that asymmetries, if they're not designed as sustainable, they are a danger, and they do not fulfill the goal of truly accommodating ethnocultural diversity. And also in this sense, the case study analysis showed that in the context where asymmetry was introduced to serve the interests of just one group or some groups and not others, it was perceived as a source of inequality, and then it was too much asymmetry. And linked to that, I think that if it's permanent or transitional, it depends. Namely that it could be everything, basically, as we can see, that asymmetry is all but a fixed design. And again, the comparative analysis showed that in some contexts, as for example in India, asymmetry was instrumental in achieving the state formation, but the overall goal was truly symmetry. And the destiny of the Indian Union will be to be more and more symmetrical. So it really depends on the goals of the constitution makers. But potentially, I think that it could be a constitutional model to address diversity in the sense of truly diversity governance. So it could be permanent, and several other case studies and constitutional systems have entrenched asymmetry in their constitutional framework. So it can be permanent. And in this sense, I think that asymmetries, if used wisely, and can really realize the subjective, the substantial equality that would be necessary to really serve minorities and include minorities within the system. So overall, I think it's a matter of sustainability and balancing asymmetries with the principle of equality. And in this sense, what would be crucial would be to develop as societies and as scholars, as constitution makers, to develop a true and engaging culture of autonomy and cooperation. So in this sense, we can collectively discuss what sustainability means, what equality means, what are the core values that should be respected and protected in order to make asymmetries sustainable. So I think that the overall discussion on asymmetries should be linked to the discussion, to the wider discussion of autonomy. And autonomy is not as a political bargain, but as a potential way to keep systems together and collectively thrive, in a sense. Then Nicolò's questions on measurement. I think that potentially everything could be measured. It really depends on of course, the research question. For my research question, I was much interested in institutional and constitutional design, and So I decided to focus on that. But again, Maja's works demonstrate that extra legal factors can be measured and accounted for in the analysis. And so I think it could be a starting point to further develop new measurements that could add to the current state of the art. And I think it can be really tough and challenging to measure legal concepts and extra legal concepts, but I found it really effective in comparative and methodological terms. Also, going beyond the fact that lawyers cannot do math and cannot use numbers, and I think it's really empowering in a certain extent. And then let me check my notes. The other two questions on quotes. So how do I explain the choice of symmetry over asymmetry? Again, I think that the overall perception that quotes have is that asymmetries are a threat to the integrity of the system. They are a source of inequality, and as such, they should be reduced to a minimum that is acceptable. But this also opens for disintegrating effects and consequences. We have seen it in Spain and to a lesser extent in India, but negating these spaces for asymmetries also reignited centrifugal forces. So courts' decisions really have an impact on the constitutional system. So actions do have consequences also when courts take action. And so again, I explained it in terms of perception of asymmetries. So if they're contested or a sort of unsettled concepts within the system, courts tend to not be brave and to choose parity and well-established or considered well-established concepts of parity among subnational entities, because that is the norm and that is what should be within multi-tier systems. And concerning Maya's questions on courts, if they distinguish between powers and fiscal arrangements, so if they do distinguish among dimensions of asymmetry, they do in terms that not all cases, not all constitutional systems do have asymmetries both in powers and in fiscal arrangements. At a constitutional, from a constitutional standpoint, for example, in Spain. It really depends on the cases, but they do tend to go hand in hand. I think that the most broad distinction is between status and then powers and fiscal arrangements on the other hand. But it really depends on the constitutional system and if they do display asymmetries in both powers and in fiscal arrangements, or just on in one of the two dimensions. I think that I answered to all questions. I don't know if the two discussants have follow-up questions on that. Otherwise, we can also open the floor for others. I don't know.
Thank you very much indeed, Lidia. And again, congratulations on this impressive work. And yeah, I don't know if the discussants have any more questions or follow-up questions. Otherwise, I will open the floor to the audience. If you want to ask a question, please raise your virtual hand, and I will give you the floor.
I already did that.
Okay. Okay. So Giuseppe, please, the floor is yours.
Oh, Okay, so thanks so much. I think, and I know that also Giacomo shares my view that this is a very important book. We already recognized that. I think that the richness of these debates really confirms that. So congratulations once again. I have 3 questions. The first one is methodological in nature, because I know that this book does not entirely correspond to the PhD thesis, and that's pretty normal because it's always like this, right? I mean, PhD thesis and books are two different beasts. This is also to what I say to my supervisors. But from a methodological point of view, what were the main challenges, in transforming, I mean, the PhD thesis into a fully fledged book? I think that your answer will be interesting also to the PhD researchers that are in the audience. The second question I have is about this tendency to re-symmetrization that you argue that to a certain extent, I mean, courts in some cases at least, I mean, tend to contribute to re-symmetrize their system. But would you describe this phenomenon as an inherent, I would say, institutional bias of constitutional courts towards systemic coherence and unity? What are the explanations that I mean behind that? And I also have another question, because of course you also deferred in the book to the necessity to preserve the sustainability of asymmetry. So my question is, I'm an old-fashioned lawyer, right? So you, I mean, convincingly showed that asymmetry is a dynamic and also gradable phenomenon. However, do you think there is a normative threshold beyond which asymmetry ceases to be integrative and becomes the constitutionally destabilizing? That's my question. It's a very naive question, I know, but please bear with me. I think that it's an interesting follow-up. And I don't know if there are, well, I'm not in charge of course, I mean, coordinating the debate. So now I give the floor to Matteo. Please, no, sorry.
Please.
Sorry.
No, I don't know if there are any other questions. Otherwise, maybe I can give back the floor to Lidia for a very brief and quick reaction to Giuseppe's questions. No other questions? Okay. Lidia, the floor is yours again, and please.
Okay, so thank you so much, Giuseppe. They're all very interesting questions and not naive at all. And I will do my best also to reassure the PhD researchers that are still connected. So the first question on the challenges in methodological terms in turning a PhD into a book. I previously described it as creative and chaotic, and I think it's the best way to picture it. And a first major challenge was to fully address the fact that I was analyzing 12 constitutional systems, that they are not a small number, and that I wanted to mix qualitative and quantitative analysis. So I really had to address head-on the issue of methodology without doing too much for a monograph. So I had to abandon the structure of a PhD thesis, and that was not easy to do, but I found it really, it was really, really important for me as a researcher, I think, because I had to, in a way, abandon the structure that I had for more than 3 years and to think about how to explain what I was doing to another audience. But I think it was really, really one of the most enriching parts of this work. And so I had to justify choices and address the wider heterogeneity of cases I was comparing. So it really taught me to think clearly, or as much clearly as possible, of course, and to address tough questions so that virtually anybody could understand them. And I think that one of the most difficult thing and challenges that to address was knowing when to stop, because this is a complex topic, and it could be looked from many angles. And at some point, I was discussing this with Maja in Antwerp a few years ago, that I just decided to, at some point, to stop going on and on and on, because otherwise I could have not come to an end. So the understanding when to just put a full stop to that, it was not easy to do, but again, really formative as an experience as a young researcher. And so the second question that Giuseppe asked on codes and symmetry, and if they perceive unity as a institutional, like as a sort of bias, if I understood correctly. And I think that they do, because as ultimate guarantee of the integrity of the constitutional system, I think that they perceive, they have a bias towards unity, interpreted as a antithesis of autonomy. And in this sense, I think that a change of perception would be needed to detach unity and I mean, autonomy and cohesion are not opposites, are the two sides of a balance. And so courts should play a much more, important and show much more awareness in do not frame these two concepts as opposites, but as complementary. And but for now, unity is the paramount value that has to be protected by courts. So I think that there is this bias, and in some cases we see that the courts can be enforcer of the central government, and again pushing for unity, and but I mean, not addressing properly the needs of subnational entities and of minorities. And then the naive question on sustainability is not naive at all, and it's really complex. Again, what is the breaking point in which, after which asymmetry is too much? Again, it's not, as Maja said, it's not an easy question, and there is no easy answer. Also because I think that is decided by the community of the people, and it's negotiated. It should be constantly negotiated. And then, of course, the constitution maker has to identify some core values that should not be touched in order to keep the system together. But again, I think that being able to discuss on what autonomy means is really important also in classrooms, because I think that, I don't know, in Italy can be really also difficult to discuss frankly about special autonomy, and in realizing why we have special autonomy and why we still have it. And I think that all the entire debate on differentiated autonomy is a really good example of how we could do a bit better on that. But yeah, again, I think that identify a core values and principles to as a sort of floor on which we can build, in a sense. And again, it's not an easy question, so I think that there could be many other answers. And yeah, I hope I answered a little bit.
Thank you very much, Lydia. If there are no other questions, probably I would abuse of my role and jump in and ask maybe just a very brief question. I have plenty of questions, but maybe we can talk about them in a different moment. But you mentioned in your introduction that, of course, asymmetric mechanism don't belong to the Western legal tradition only. And so maybe you can elaborate a bit on the methodological, let's say, structure of the book and how it is possible to compare, I don't know, liberal democracy in the Western sense, in the Western, let's say, structure with, I don't know, Iraq or India, Indonesia, and so on. And maybe as a follow-up question, do you believe that crisis-driven asymmetries, such as in Iraq, function differently from historically gradual ones, such as, I don't know, in Belgium or Canada, and so on? Thank you very much again, Lydia.
Okay, so thank you so much, Matteo. Is a really interesting question, and again, I think that that part of the book where I justify the case selection was one of the methodological challenges that I was referencing to before when I was answering to Giuseppe's question. So I treat apparently very heterogeneous cases. But and this was one of the questions also during my PhD defense. So how can I compare Iraq and Belgium and Canada all together? And indeed it is true. But then I actually wanted to look at current, for example, democracy index, and it was really disheartening to see that there are very, very few fully fledged democracy or fully liberal democracies. And the majority of my cases were flawed democracies, and few hybrid regimes, and very few autocratic regimes. But in this sense, seeing that asymmetries were in all these typologies, again, was a sort of common ground among cases. And what I wanted to explore was not the former state, but was the phenomenon and manifestation of asymmetry. Also because asymmetry can serve the interest of the majority in whatever context. So in this sense, addressing heterogeneity was difficult, but it was really an added value, I think, to the analysis. Also realizing that what we perceive as liberal democracies are no longer truly liberal democracies. And the second question was, wait, remind me, because I didn't make time to write it down. The second question? Wait, you're muted.
You are muted, Matteo.
Okay.
Sorry. The second question was about the crisis-driven asymmetries, such as in Iraq. Yeah, exactly. If they function in the same way, more or less, or not, compared to the Western, let's say, traditional.
So the crisis of asymmetries across different settings. This is something that I would need to look a bit more in detail, because the interesting aspect of Iraq is that asymmetry was designed to serve just from a constitutional design standpoint, just an area of Iraq, so the Kurdistan region, and the declared open possibility to form other regions is only on paper, because the efforts in creating new regions have been blocked by the central government and legislature. And that opened a crisis, but from a different trajectory than other countries. For instance, in Spain, the more contested debate on asymmetry came from quotes from the decision of the Spanish Constitutional Tribunal that negated asymmetries and that pressed for a disintegrative dynamic and the calls from secession and independence from Catalonia. So I think that they can have different trajectories, especially if they have open constitutional clause on the establishment of special and differentiated treatments. In this sense, both Spain and Iraq in this respect have open clauses, because they do not establish ex ante some territories that have special autonomy, as in Italy with its special regions, but they do open for constitutional procedures to establish differentiated treatment. But they can have, they can open to crisis according to different trajectories, even either by courts, by the action of courts, or by constitutional design in action, meaning that the implicit objective of accommodating the claims of autonomy from Kurdistan was not explicit in the constitution, but was implicit in the constitutional process and arrangements in that region. Either way, I think that asymmetries proved to be more unstable in those countries where there was not a full negotiation of why asymmetries were introduced. And so, yeah, I think that it's something that I would like to study again, because it's something that I found also as a recurring theme in following works on asymmetries, especially in Southeast Asia. Asymmetries were either rejected completely and just tolerated, and in other cases were entrenched as a constitutive part of the constitutional system. So, and in both cases, they could be source of crisis. So it's a really interesting suggestion, and so thank you so much.
So thank you, Lidia. Okay, there is another question. Let's say a super quick question, because we are running out of time, but please, Rachele, the floor is yours.
Good afternoon, everybody, and thank you very much for your super interesting presentation. I just want to say that I'm an international lawyer, so this is also, probably related to my first question. Actually, with regard to your first part of the book, I was wondering whether also the treaty-making power of, let's say, internal units could be considered in your empirical test of the intensity of asymmetry within a state. And a second question is related to your methodological part. So with regard to the role of colonization in asymmetry, and in particular, I was asking myself whether colonization had, in your view, had a role in the relationship also between between crisis and centralization, so asymmetry and crisis. Thank you.
Wait, that I lost Matteo. Okay. I can directly answer, I think, no, because we have just a few minutes.
Exactly. Thank you.
Okay. So Rachele, thank you so much for your questions. Treaty-making powers are actually among the categories of the indexes developed by Patricia Poppelier. So they could be measured, and in deciding what indexes to select, because they are widely encompassing, so there are much more than the one that I selected. I had to make choices in terms of feasibility, and I had some expectations on what indexes could grasp in a more effective way the degree of asymmetries. But they do, they could be measured. And the idea is that these indexes can be used in the future to complement my analysis. So whoever wants to use them can add to my work. And another interesting aspect related to that is that Patricia Poppelier's indexes also take into account the European Union level and the involvement of subnational entities in the European Union level, so supranational level. I had to choose not to select them because not all countries, of course, were part of the European Union. But if you want to do a more restricted analysis, you could also add that layer in the measurement. And the second question on methodology and the role of colonization, I think that colonization and the colonial experience did play a role in the crisis and in the acceptance or rejection of asymmetries, mainly because asymmetries and first and foremost the federal structure in those countries that have adopted the federal structure were used as a means to control and to exercise power. So along the same principle of divide and conquer, the use of asymmetries was a way to better exercise power, and this left a trace within the systems. Also because in some cases asymmetries were granted in the post-colonial independence phase just to keep the system together, but without a really clear picture of what the constitutional system should be and could be in the post-colonial experience. So in some sense, I think that that kind of attitude towards decentralization, territorial decentralization, was maintained also in the post-colonial era. So yeah, I think that it did play a really huge role. And yeah, I think it's the role of colonialism should be further studied in federal systems because I think there's still so much to learn and to understand. So I think it's a really timely question.
So thank you very much, Lydia. I'm afraid we have definitely run out of time. So let me thank our author, Lydia, for sharing this important book work with us, and our discussants, Nicolò and Maja, for their very stimulating engagement. I believe, let me say that I believe that today's discussion has highlighted not only the richness of Lydia's book, again, Asymmetries, Courts and Comparative Constitutional Law, but also, let's say, the broader relevance of its topic, not only for comparative public law, but also for international law. And so thank you very much also to our audience, Giuseppe, Rachele, and for the questions and excellent remarks. And with that, I would like to officially close today's